Hi everyone, Armine Bazikyan here from Bazikyan Law Group. This month we thought we would do something a little bit different from the past. We thought that we would do a case analysis and answer the question, how much does a probated case actually end up costing loved ones? This is a very important question that we get asked all the time, and what we wanted to do is, instead of doing a video on what the probate costs actually are statutorily, I thought it would be interesting to do an actual case study from one of our cases that we had in the office and kind of take you through and break it down step by step so that you're involved in the process and you see on a more factual basis what an actual probate looks like. So this is actually a case that our office that we helped the family with, and we recently closed up, and we are going to go through and talk about some of the facts of the case. Now, before we get started, I did want to remind you what a probate is. A probate is basically what happens when a person passes away and they did not do any planning, any documentation was signed, or they did sign something, but it was just a basic will. And therefore, we are going to court to ask a judge to make a ruling on this. So that's what probating a loved one's estate actually means. And we have prior blogs on this, which are linked to this blog, so feel free to peruse through those prior blogs if you want to read more about it. So for the purposes of this video, we will call the person that passed away G. It's an abbreviated version of the name. And G unfortunately passed away suddenly. G left behind a wife and 3 children, okay? And luckily for him, all 3 of his children were adults, so we don't have any issues of minors in this case. So G's ultimate heirs in this case were wife and then 3 kids, so 4 individuals involved. Now, going back a step further, G did not do any type of planning. He did not prepare a will, he did not prepare a trust, he had absolutely no paperwork done. And the only asset that G owned at his death in his name was a home, the property that he lived in, so a real piece of property. We call it real estate or real property in the legal world. So he left behind one property and nothing else. Now, if we take a step back and we look at what the results would be, we have to first analyze the case. Now, because he didn't do any paperwork, the judge actually has to open up that big book of laws and look at what the probate code says in order to decide what happens. Because G didn't leave any instructions for the judge. He left nothing in writing that the judge is going to follow. So the judge has to open up the probate code and see how the distribution plays out. And because G did not do any paperwork, his estate is called intestate, meaning intestate is just a fancy word for he didn't leave behind any paperwork that we can read and figure out what he wanted. So because he died intestate, we need to follow the code section in the probate code, in the probate laws that talk about intestate succession. And according to the code section for intestate succession, his wife inherits 1/3 of the property, and the remaining 2/3 must be shared between all children that he has at the time. So the 3 kids have to split that 2/3 interest, giving them each a 2/9 interest, okay? So that's what's gonna be the result of this case. We're gonna have all 4 of these individuals sharing this property in some capacity or another. Now let's take a step back and kind of break down the cost of this case to see what it actually ended up costing the loved ones. Because remember, he had no paperwork done, we ended up in court. Now, during the probate proceeding, once we get to the end and we're ready to distribute to all these 4 people, the court or the judge will actually approve all of these fees before they are paid. That's a very key important part of probate, is that a judge has to okay the fees in order for the fees to be paid. So if you are coming across someone who wants you to pay them like a flat fee to probate an estate, they are not following the law, okay? These people are breaking the law. So in this particular case, at the date of death, this property was worth around $820,000. And so we know it was worth $820 because the court actually sent out a probate referee to evaluate the assets, to give a price to the court about what the assets are worth. So a probate referee looked at the property comps and said, okay, at the time of G's death, this property was valued at $820,100, right? And so what the court does is that's our magic number that we base all the costs on. And if you remember in prior videos, we talked about probate being statutory fees, meaning the fees that an attorney gets paid are going to be based on what the value of that asset was, how much it was worth. So if in this case the property is worth $820,000, all of the fees in this case are going to be based on that $820,000 number, including my attorney's fees. Okay. Now the first $100,000 of value is charged by the court at 4%. The second $100,000 is charged at 3%, and the remaining $800,000 of whatever the assets are worth are charged at 2%. And we'll stop right there because our value is not over $1 million here. And so you could see that these numbers quickly add up, and we have about a $19,402 in probate statutory attorney's fees that the loved ones will owe at the end of this case. Okay. Now it's very important to know that this $19,000 has to be, once again, approved by the court before it's distributed. And the second thing to also keep in mind is that this is a statutory fee, meaning this fee is written in the law. You cannot negotiate it with the attorney, right? The attorney can't decide what to charge you more or less. The attorney has to follow the statutory rules here. And this is what the court and the law says that the attorney is entitled to get paid. Now, in addition to these fees, there will also be other fees, and these other fees are going to cover things like court filing fees, referee, appraisal fees, other miscellaneous expenses and court costs that come up, recording fees. So all of those fees, miscellaneous fees we'll call them in this case, came out to be about $1,749. So in this case, the family, in addition to paying the attorney fees, incurred about $1,750 in miscellaneous filing and court and other fees. That was their responsibility. And so if we take a step back and we see what the results of this case was, in summary, at the end, mom inherited 1/3 of the property, the wife, right? The wife became an owner of only 1/3 of this entire property that she is living in. And each child became an owner of 2/9. Okay, they shared the remaining 2/3 interest of this property. And so all 4 of these individuals are now basically partners and co-owners of this property, okay? So that's the end result for who gets the property. It didn't go to the state of California. It didn't go to the government. It still ended up with the family. However, mom had to share it with kids in this case, which may not have been the result or the desired outcome or consequence that G wanted. Along with who inherits, the total cost out the door from start to finish for this family rounded out to be about $21,000. And it took the family about 1.5 years from start to finish for us to help them go from probate to the end of probate. So the total length of time that all of this took place was about 1 year and a couple of months. Which is a pretty, very, very low number. So on average, probate lasts about minimum 1 year to 2 years, depending on what complications come up. In this particular case, we had no complications come up. It was very, very simple in the sense that we didn't have people fighting the family members for interest. We didn't have creditor issues. You know, dad didn't have any Medi-Cal recovery claims. So it was very straightforward. The 4 individuals inherited in some portion or another. The total cost was about $21,000 on the family, and it took about, let's say, 1.5 years from start to finish. Now, if we take a step back and we ask the question, what if G had done a trust? What if he had actually gone in to see an estate attorney and did proper planning ahead of time? In my opinion, based on our attorney fees here at our office, if G had, let's say, consulted with us and seen us, and we had done an estate plan for him, and then following his death, we had helped the family administer that trust, do the legal steps for that trust, the legal process. In our opinion, we would have been about $6,000 to $8,000 in total fees. And as you can tell, based on the 21,000 number, this would have saved the family a good $13,000 to $15,000 in legal fees and costs. So it would have been a huge savings, but it would have required G to actually contact an attorney and do the proper planning. And I want to stress that would have been the result if proper planning was done. If there were improper planning, meaning a non-attorney or a legal service doing the documentation, I want to warn that it actually ends up costing the family more, because when we find mistakes after the person dies, we actually have to end up in court again. So then in that case, not only will you have the initial fees for setting up your estate plan, but also some additional costs that the mistakes of that professional wannabe would have cost your family and friends. So make sure that you are doing proper planning if you have intentions of putting together legal documents ahead of time, and make sure that you are consulting with a licensed attorney, preferably a licensed attorney who's certified in estate planning and probate, okay? As always, I'm a certified specialist in estate planning and probate administration. My name is Armine Bazikyan, and we'd be happy to hold a free 15-minute consultation for you guys. Feel free to contact our office. Have a good one. Bye-bye.